I would like to first draw the attention of everyone, all the concerned citizens, in respect of the very distressing situation which has unfolded pertaining to the almost crippling situation of Garo Hills Autonomous District Council. You are all aware that particularly the employees of Garo Hills Autonomous District Council have been off and on resorting to some kind of peaceful educational program to draw the attention of the authorities concerned, particularly the state government, in respect of the suffering that they were subjected because of non-receipt of their salaries. It is a matter of concern that the employees of the Garo Hills Autonomous District Council were subjected to all kinds of mental agony, and we can understand how a person will be subjected to in terms of mental distress if one has to struggle in spite of being an employee of a government institution to have 2 square meals for their loving children and also to educate their children. A matter has been flagged before the people through various available means of communication to draw the attention of the government pertaining to non-payment of the salary by the employees of the ADCs. And the fact is that for last 42 months, the employees have not been paid salary. So you can understand the quantum of financial distress that these employees must have been subjected to, with its own ramification thereof. And at the same time, it is not just the question of the kind of agonizing experiences to which the employees are subjected, but also the impact of this on the overall functioning and administration of the ADCs. When the employees who are vested with the responsibility of attending to all kinds of official duties for the effective administration and functioning of the GHADC, Garo Hills Autonomous District Council, which is vested with the responsibility of implementing all necessary programs and policies as mandated under the 6th Schedule of the Constitution. Now, the impact of these can be somehow understood by each one of us as to how the ADC in respect of Garo Hills Autonomous District Council may be really functioning. And because of this, how the common man, the people who had different works with the ADCs are affected. The employees have been in agitation since 7th of this month, today is 31st. And it is quite distressing to see that till now the authorities concerned in the ADCs and the government have not come out with any kind of positive response, reflecting the quantum of insensitivity towards resolving this problem. Now, what is the importance of these autonomous district councils? How the provision as has been enshrined in the Constitution as far as the 6th Schedule of the Constitution of India is concerned, how important it is for us, for the tribals of the state, and how 6th Schedule, the provision of the Constitution, the mandate of the sixth schedule of the Constitution of India, how it has been designed and conceptualized by the framers of the Constitution. It was because they understood the need to have this special provision for our people. Do you think the people of the state will agree when any government of the day who is vested with the power to amend the Constitution come up with a proposal to say that they want to do away, like how they did to Article 370? Will our people agree? We will not agree. Our people will not agree because we understand the importance of this provision, this mandate of the Constitution of India. Now, if we understand the importance of this provision of this Constitution of India in protecting our way of life, our culture, our traditional laws and customary practices, our ownership over the land, etc., in as far as the rights and powers of the tribals which are vested upon by the mandate of the Constitution is concerned. If we know all of them, then can anybody not realize the binding responsibility of any of the government of the day to strengthen the provision of the Constitution in as far as the sixth schedule is concerned, so that we empower the district council furthermore? And this is precisely what we try to do. I think you will appreciate the fact that when we engage ourselves by entering into a tripartite agreement to have a suspension of operation with the then proscribed organization NBC, wherein Union government, the state government, and NBC in the tripartite agreement for SOOO, suspension of operation, to give effect to the tax settlement agreement eventually. What did we do? How did we ultimately arrive at that tax settlement agreement? The tax settlement agreement was arrived at by somehow an exhaustive engagement with all the concerned civil society organizations representing the people, including the signatories, which means the then proscribed NBC, to give an alternative to their demand of a separate statehood, by rather strengthening the ADCs, which required certain minor amendments, additions of certain additional added power to the ADCs. And they were discussed exhaustively by all the political parties at that point of time when we were in the government, prior to actually submitting it before the government of India, submitting it to the government of India for their consideration. And we all agreed that there is a felt need to strengthen ADCs, and the associated amendment of the provision of the sixth schedule of the Constitution of India to achieve that objective, which included, a provision to ensure that there is an uninterrupted flow of resources and finances to the ADCs in order to enable them to fulfill those intent which were factored in the tax settlement agreement. Added responsibility, added power will require added resources. And today we are talking about, forget about the added resources. Even prior to these provisions which were required to be incorporated in the form of a proposed amendment of the Constitution of India in as far as the sixth schedule is concerned, the necessary support which has been made available to ADCs prior to the signing of tax settlement agreement, or rather implementation of this tax settlement agreement, is now not forthcoming. Now, if you will recollect, while we were engaging in this exercise, even before the tax settlement agreement was signed in 2014, we came up with the Meghalaya State Finance Commission Act 2012. What is the intent of this act? This is available. It is in public domain. The intent of this act, in a nutshell, is to further strengthen the local bodies, particularly ADCs, autonomous district councils, and also the municipality bodies, because we had so much of problem pertaining to all those dictates which come from Government of India for holding elections in municipalities and all, without which you cannot have access to all those funds which are somehow provided by Government of India. So we needed to come up with this Meghalaya State Finance Commission Act, so that the state can empower these ADCs and also the municipality boards in as far as the resources are concerned, because every responsibility vested upon these local bodies, particularly ADCs and municipalities, these responsibilities can be very effectively somehow whatever responsibilities are vested upon them, they must be able to fulfill them in the right perspective. That requires finances, resources. Therefore, the State Finance Commission Act deals with this responsibility of the state to see how much resources are required for these ADCs, autonomous district councils, and how much is the capacity of their concerned respective ADCs to mop up the resources on their own from all the available resources in terms of the revenues which they generate based on the mandate of the Constitution, and what is the shortage, whether it is a shortage in respect of the revenue expenditure, and in addition to that, what are the mandate of the Constitution based on which they'll have to also plan for investment in as far as the capital expenditure is concerned, and how this whole requirement of the ADCs will be examined, and how the resources available with the states will be then decided upon as to how much of the resources will be transferred to the ADCs by the respective finance commissions for different responsibilities which are vested upon the respective ADCs and the local bodies. Why is the state not acting on it? The act is there, act is notified, it is in public domain. That means the intent is very clear, the priority is very clear. Indirectly, are they trying to cripple these ADCs? I would like to say that this issue of the problem being faced by the employees of Garhwal's Autonomous District Council should not be taken as a issue of Garhwal's Autonomous District Council in isolation. It should be taken as a problem, as an alarm bell for all the people of the state, because it only reflects the complete insensitivity of the state government towards their own responsibilities in as far as empowering the Autonomous District Council to fulfill their responsibility inconsistent with the provision of the 6th schedule of the Constitution of the Constitution of India is concerned. It is a complete reflection of their insensitivity, and I have to question also, do they want to really slowly cripple the ADC so that they will have its own natural death? It is questionable. Do they have some other predetermined malafide intention by not acting, crippling the ADCs? Does the provision of the Constitution doesn't give that kind of responsibility towards the states and the union government? Have we not signed the tax settlement agreement 2014? The Government of India also is equally responsible to answer, because you may recollect that when the state government decided to notify the election for ADCs, there was a letter which came from MHA informing the state that the union government intend to take on all the measures to amend the relevant provisions of the 6th schedule of the Constitution of India in order to give effect to the mandate of the tax settlement agreement which were factored in the agreement, in as far as the tax settlement between Government of India, State Government of Meghalaya and the NBC was concerned. So it was seen as a natural responsibility vested upon the union government. But subsequently, this amendment has not taken place till now. But while the amendment was somehow pending before the union government's consideration and tabling of the same before the parliament, we took up the issue with government of India that having signed this tax settlement agreement, it is important for union government of India to support the ADCs and provide fund which should be a special assistance directly for the ADCs. We were able to prevail upon government of India. And for that matter, I must thank the government of India that pending this whole amendment of the provision of the 6th Schedule of the Constitution of India to give effect to the intent of whatever were factored in the tax settlement agreement by government of India and then state government and NBC, at least they agreed to provide direct assistance through the state government, which were to be decided upon by the union government and released to the ADCs, respective ADCs. And I must remind ourselves that yes, in 2015-16, you might recollect that substantial amount of money for the first time in the history was released by government of India to 3 respective ADCs, KHADC, JHADC, and GHADC. And to be more specific about Garo's Autonomous District Council, the money released at that first time, that first ever special central assistance for ADCs was to the tune of 100.71 crore, which was released by our government. We didn't delay in releasing the fund. But you are aware that after this fund was released to the Garo's Autonomous District Council, in respect of Garo's Autonomous District Council, there was allegation of misuse of the fund. And eventually, there are lots of these allegations which were the result of the information which were made available through RTI. And then subsequently, people decided to take head on with those authorities who were considered responsible for misuse of the fund released by Government of India. And ultimately, the case was taken up by the Lok Ayukta, Meghalaya Lok Ayukta. But unfortunately, that case is still pending. That means the overall fund which was already coming to the ADCs was derailed by that kind of alleged misappropriation of the fund. Rather than utilizing the fund to really strengthen the ADCs and to ask more from Government of India, this fund became, a matter of question as to, rather to question the intent of the people who were somehow pleading for strengthening the ADCs. And it gave an opportunity for Government of India to ask questions. Now, therefore, having said this, there are reasons for us to say that the case is pending before the Lok Ayukta in as far as the alleged irregularity which was taken up by the Meghalaya Lok Ayukta must be disposed of at RDS. These are important issues because it involves alleged irregularities pertaining to the fund which has been released for the purpose of giving fruition to the provisions which were factored in the tax settlement agreement. These are important for the people of Meghalaya to understand that ADCs must be given the kind of support they need. And then if they are somehow, for whatever reasons, found to be weak in terms of mopping up the kind of resources that they need, then the provision of whatever is mandated by the Meghalaya State Finance Commission Act must be utilized as the effective instrument to ensure that the ADCs are not left to this kind of situation where they are found to be helpless. I can see that the tendency of the present government is that, okay, ADCs are autonomous district councils, so let them just take care of their own issues. It is not. It is not. Because the resources, how they have to be utilized, is well defined by that act. We have to understand this. These are government institutions. Governor of the state is invariably, indispensably integral part of ADCs. Yes. You look at the Constitution. So, we all know that ADCs are part and parcel of our different tier of government. We have to understand one fact that Meghalaya doesn't have the Panchayati Raj system. Why do we have no Panchayati Raj system? Because we have the ADCs. And ADCs must be given the kind of power, the empowerment, which it deserves in the best interest of our Jack Penriu. Therefore, friends who think about the interest of protecting the inherent strength that our people have demonstrated by virtue of our way of life, our own tried and tested customary laws, traditional laws, customary practices, traditional practices, to further strengthen them and to see that our traditional institutions are under no circumstances found to be weak. Therefore, all this support which is required by the ADCs must be given, and substantial work to enable any government of the day to accomplish this responsibility has already been done. The law is there, law has been passed, and there is no reason why the state government should not constitute that Meghalaya State Finance Commission as per the mandate of the Act, and see that the resources needed by the ADCs are appropriately worked out in sync with the provision of the Act, and see that resources needed to be transferred to the ADCs are accomplished.